Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Today we're going to talk about the case that eliminated the Chevron deference doctrine. So Chevron allowed a federal agency to change a law by reinterpreting its definitions and standards and thereby change it without going through Congress. In other words, instead of having Congress amend a statute to impose new requirements, the federal agencies would simply write a new regulation that imposed a new duty or a new fee or something like that. And they could do that because the courts had been directed in this Chevron case to look the other way and accept any reasonable interpretation offered up by a federal agency. It was one of the worst decisions ever written by Judge Stevens. Now, the Chevron deference doctrine was a principle of administrative law. It came up in the Administrative Procedures Act, and it compelled courts to defer to a federal agency's reasonable interpretation of an ambiguous statute that the agency administered. So, to begin with, in order to apply Chevron, the agency statute had to be ambiguous. And you're probably thinking, well, most statutes are written by lawyers. They certainly couldn't be ambiguous. Well, any lawyer who can't find an ambiguity in the statute somewhere is not worth his law license. The doctrine emerged from this case called Chevron USA versus the Natural Resources Defense Council. Now, the case involved an Environmental Protection Agency interpretation of a provision of the Clean Air Act. The APA had adopted a regulatory definition known as the bubble concept to determine the meaning of the term stationary source under the Act. Now, that term, stationary source, was not defined under the Act. The Supreme Court in that case wrote that courts should defer to agency interpretations of ambiguous statutes as long as they are reasonable. So it involved a two-step process. Step one, the court had to determine whether the statute was ambiguous regarding the specific issue at play. And if the statute was clear, well, the court and the agency had to follow the clear intent of Congress. Step two, if the statute was ambiguous, the court must determine whether the agency's interpretation is reasonable or permissible. And if it is, the court would defer to that agency's interpretation. Now, Chevron deference significantly influenced administrative law. First of all, it helped shape the balance of power between courts and administrative agencies. A lot of times when a regulation was written and it was pretty clear that what they said was a reasonable interpretation, most of the time those cases did not get challenged and the courts didn't have to act. So in some respects, it was somewhat efficient. But it also allowed agencies a lot more flexibility in interpreting and implementing laws within their purview. A good example of that is under President Trump, where the ATF decided that bump stocks were actually machine guns, which of course the Supreme Court in this last version determined that they were not machine guns because the law did not say that was a machine gun. The law defined it, and the agency's interpretation was unreasonable. So it reduced the frequency of judicial intervention in agency decision-making, and that's why many people thought that it was a good deal. And of course, the dozens of bureaucrats in Washington, D.C. tend to think it was a good deal because it helped solidify some of their jobs. Some argued that Chevron deference gave way too much power to the administrative agencies. It undermined the role of the judiciary, and it led to the potential overreach by executive branch. It conflicted with the judiciary's role under Article 3 to say what the law was, and with the legislative role of Congress and its responsibility to say explicitly what was required in a statute. One of the things you'll notice if you ever read a federal statute is most of them, particularly those that have any kind of penal effect, have a definition section at the very beginning where they define all of the terms the statute uses. Over the years, Chevron deference faced scrutiny and calls for reform. Some justices and legal scholars advocated for limiting or eliminating the doctrine to restore the balance of power among the agencies and the branches of government. And then along came some people with a fish story. Loperbright versus Raimondo. Recognizing the resultant overfishing and need for sound management of fishery resources, Congress enacted the Magnuson-Stevens Fishery Conservation and Management Act. The court abbreviates it the MSA. The MSA and subsequent amendments extended the jurisdiction of the United States to 200 nautical miles beyond the U.S. territorial sea limits, which are 12 miles, and claimed exclusive fishery management authority over all fish within that area, known as the Exclusive Economic Zone. The National Marine Fisheries Service, NMFS, administers the MSA under a delegation from the Secretary of Commerce, Raimondo. It imposed on private companies a new requirement that they allow a monitor on board their vessels to monitor fishing and pay the salary of the monitor if federal funds were not available. If the NMFS determined that an observer was required, but they declined to assign a government-paid one, the vessel had to contract with and pay for a government-certified third-party observer. They estimated that would cost about $710 per day, and it would reduce the annual returns to the vessel owner by up to 20%. So in essence, they were legislating through regulation a 20% tax on all of the vessel owners who fished in the exclusive fishery zone. So along came Loperbright, which was a family-owned business, and it challenged the rule under the APA, the Administrative Procedures Act. It argued that it did not authorize the mandate. Well, as you might expect, the district court, applying Chevron, granted summary judgment to the Department of Commerce. And the D.C. Circuit affirmed, saying because congressional intent was unclear that deference was appropriate, and SCOTUS used that as the example to remove this blight from the law. In the case, the reviewing courts applied Chevron's framework to resolve in favor of the government challenges by the petitioners to a rule promulgated by the National Marine Fisheries Service, which incorporated the APA. The APA required courts to exercise their independent judgment in deciding whether an agency had acted within its statutory authority, and courts can't defer to an agency interpretation of law simply because a statute is ambiguous, and the court overruled the Chevron doctrine in that many words. Now, Article 3 of the Constitution assigns to the federal judiciary the responsibility and power to adjudicate cases and controversies, concrete disputes with consequences for the parties involved. The framers appreciated that the laws judges would necessarily apply in resolving those disputes would not always be clear, but envisioned that the final interpretation would be the proper and peculiar province of the courts. As Chief Justice Marshall declared in the foundational decision Marbury v. Madison, it is emphatically the province and duty of the judicial department to say what the law is. In the decades following Marbury, when the meaning of the statute was at issue, the judicial role was to interpret the act of Congress in order to ascertain the rights of the parties. And the court has always given the most respectful consideration to executive branch interpretations, usually because the officers concerned were able men, and they were masters of the subject, and they may even have been involved in the drafting of the laws at issue. But respect, the court said, was just that. The views of the executive branch could inform the judgment of the judiciary, but did not supersede it. In cases where a court's own judgment differed from that of other high functionaries, the court was not at liberty to surrender or to waive it. That was the rule going up through the 1930s, and then the New Deal hit. And there were a whole bunch of expansions of the federal bureaucracy under the New Deal. And in 1946, to rein in this growing, what Trump and his allies call the deep state, in order to rein in the deep state, they passed the Administrative Procedures Act, quote, as a check upon the administrators whose zeal might otherwise have carried them to excesses not contemplated in legislation creating their offices, close quote. The APA prescribed procedures for agency action and delineated the basic contours of judicial review for each such action. And it codified for agency cases the unremarkable yet very elemental proposition that judicial practice dating back to Marbury that courts decide legal questions by applying their own judgment. Courts exercising independent judgment in determining the meaning of statutory provisions consistent with the APA may, as they have from the start, seek aid from the interpretations of those responsible for implementing those statutes. And when the best reading of a statute is that it delegates discretionary authority to an agency, the role of a reviewing court under the APA is, as always, to independently interpret the statute and effectuate the will of Congress, subject to constitutional limits. And the only way to ensure that a law will not merely change erratically but will develop in a principled and intelligent fashion is for the court to leave Chevron deference behind. By overruling Chevron, the court does not call into question prior cases that relied on Chevron framework. In other words, if you lost on the basis of framework a year or 2 or 3 years ago, don't come crying to us now. The holdings of those cases that specific agency actions are lawful, including the Clean Air Act holding of Chevron itself, are still subject to statutory stare decisis despite the court's change in its interpretive methodology. Mere reliance on Chevron can't constitute special justification for overruling such a holding. So at the bottom line, what happened here? The Supreme Court decided that courts and not unelected bureaucrats should decide questions of law. And that's because courts are always populated by judges. Judges themselves are lawyers. And there are a lot of people in the federal bureaucracy who draft these rules, who implement these rules, and who enforce these rules, who are not lawyers and who may indeed be going well past the limits of congressional authority dictated by their governing statute. And a good example of that, again, is back to the Trump-era ATF, who issued the bump stock rule. As we went through on that opinion, it was very clear, at least to me, that it was not a machine gun. The ATF did not have the authority that it needed to pass that regulation, and as a result, it was overturned. And I think, again, that is an excellent holding from the United States Supreme Court. Did that mean I rushed right out and bought a bump stock? Of course not. I wouldn't do that. But the bottom line, the courts, not the agency, should be the determiner of what the law actually says. So what do you think? Do you think that's a good ruling? Do you think that maybe courts ought to be in the business of interpreting the law and not bureaucrats in D.C.? One of the things that I think has happened in large part, particularly over the last probably 30 years, is that the District of Columbia has become more isolated from the rest of the country. And as a result, I think in some respects they have lost touch with a lot of the citizenry out there. So I view this as a particularly good decision. If you have an alternate view, drop it in the comments down below, or you can email me at the address above. Like, share, subscribe. If you have the opportunity today, do something nice for somebody. And then tomorrow, come on back down here, catch me at the beach, and we'll talk about something else fun. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.